Join ForumIAS Academy, trusted by hundreds of toppers, including IAS Rank 1 𝐂𝐡𝐚𝐬𝐫𝐢𝐻𝐵.
Hi, my name is Krishnan. Today I'll be doing the Hindi news analysis. These are the 5 articles that will be discussed today, and towards the end we'll see previous year questions. So the first article is about Supreme Court telling the government that it is very deeply disturbed by what is happening in Manipur. So let's see what the Chief Justice is telling about this. So what has happened? Chief Justice of India summoned the government's top law officers. Who are the top law officers? Attorney General and Solicitor General. So he summoned them and he told them that the court was deeply disturbed by what was happening in Manipur. So most of you might have seen those videos. So the Chief Justice told the center and the government of Manipur they should take some action and bring the perpetrators to book, or they should step aside and let the judiciary take some action. So this is a very strong words, right? So next is telling using women as instrument of perpetrating violence in a charged atmosphere is simply unacceptable in a constitutional democracy. So this is what he's telling. So what this court's initiative signals? It signals that the court is upping the ante from its past consistent stand. The judicial intervention in the Manipur situation should only extend to humanitarian issues. So now the Supreme Court is portraying itself as a platform to facilitate the restoration of peace in the state. So the court is telling we are placing our trust in the center and the state government to provide security for the people trapped in the violence. So the court assembled today, and the Chief Justice remark came immediately after the court assembled for the day's work. And both the Attorney General and Solicitor General were already waiting in the front row of the courtroom. So they're telling this is a gross violation. So what they're exactly telling? The court is deeply disturbed by the visuals which have appeared in the media since yesterday, depicting the perpetration of sexual assault and violence on women in Manipur. So this is what they are telling. So they are taking suo motu cognizance. That is, nobody will file case. They themselves will take the case. That is called suo motu cognizance. So what they are telling, the video visuals indicate that there is gross constitutional violations and infraction of human rights. So the court can look into all these things. And what the Chief Justice is telling, it does not matter if the video was a recent one or recorded in May. What matters is that what is happening is simply unacceptable. This is the grossest of constitutional and human rights violation, and they are expressing their concern over it. And finally is telling we will give the government a little time to take action, or we will take action. So this is a very strong word. And the Attorney General assured the court that he would convey its concern to the government. And it is the Solicitor General who has been appearing for the Manipur government in a series of separate cases related to the violence. And he has given is consistently telling things are calming down in the state, and he's telling we share the concern of the courts. Even we are concerned about what is happening, but things are calming down. Like that he's telling. And what the court is telling, they want immediate action. They're telling despite oral assurances, the bench, that is the bench headed by the Chief Justice, is telling they have made it clear to the central and state governments they wanted immediate action. So they wanted to see. So immediately, are they taking any action or not? They wanted to see that. So what they are telling, we direct both the central and the Manipur governments to take immediate steps, remedial, rehabilitative, and preventive. So what they are telling, take immediate steps. It should be remedial, rehabilitative, and preventive. And the next day they should come and tell the court. I mean, the next when is the next listing on that day, they should come and tell the court what actions they have taken. And the affidavit should be filed by the Union Home Secretary and Chief Secretary of the state of Manipur. and it also directed the central and state governments to provide details of the steps taken by them. They're telling what have you done to the perpetrators of this incident. So few people are criminals, right? So what are you doing to those criminals? Have you take them into account? So somebody should be held accountable for what has happened in Manipur, right? So they're telling you punish the criminals and you ensure that such incidents do not happen in the future. Even if all this riots are going on, at least make sure that all these things are not happening to women. And saying this, they listed the next hearing for July 28. Now let us move on to the next article. This article is about Delhi government's challenge to centers, ordinance and services. So Constitution Bench is going to take it. So in this article, I'll explain what the problem is really about and why there is again tussle between center and the state. So what really happened is, who's got the powers to regulate services in Delhi? Services means people, those IAS, IPS officers, their allowances, postings, transfers. So who's got power to regulate all this? So is it the central government or the Delhi government? So who's got the power? So recently Supreme Court gave its judgment also. It said only the Delhi government has got the power to do all these things. But what the center did, immediately they passed the ordinance quashing what the Supreme Court has said. That is, they came up with the ordinance telling again that only that central government can have control over services. So in this regard, we'll see what this article is talking about. So what happened? The Supreme Court on July 20 referred the Delhi government's challenge against the central ordinance. So what is this ordinance? It returns power over civil services in the national capital to the LG. So who is supposed to have the power over civil services? Delhi government only. But what this ordinance is doing, it is giving back the power to Lieutenant Governor. So basically what the Supreme Court verdict said, they're just doing the opposite of it, and they're not doing it through a law also, they're doing it through an ordinance. So what Supreme Court did yesterday, they told we are going to take this to Constitution Bench. So this Constitution Bench will hear the case. So you see, there is a monsoon session also going on in the Parliament, and at the same time, Supreme Court is telling we'll take this issue to the Constitution Bench. But what this central government is telling, they are telling the court that you wait for some time, because we are this National Capital Territory of Delhi Ordinance 2023. Earlier it was passed as an ordinance. They are telling you wait for some more time, we'll make it a law. But what the Supreme Court is telling, we will refer this to the Constitution Bench and we'll upload our order in the evening. So, but what Delhi government wanted, they wanted to take this case immediately, but the Chief Justice said, no, because the Constitution Bench for hearing the abrogation of Article 370 in Jammu Kashmir. So that is going to come up soon. So they are telling we are preparing for it and everything has been set up for it. So we can't take this immediately. So senior advocate Abhishek Manu Singhvi, who is representing the Delhi government, he is telling the sooner the case is taken, the better it is, because the whole system of governance in the national capital was in a state of paralysis, because nobody knows who they are under. And what is telling, no bureaucrat is taking order from the from the Delhi government. And 433 consultants to the Legislative Assembly have been fired by the LG. So what Mr. Singhvi is telling, so you please take up this article before the Constitution Bench takes up the Article 370. But Chief Justice is telling, no, see, it's too late to make any changes, because this Article 370 is already scheduled for August 2, and the hearing preparations and study for the hearing were already underway. So that is why telling on August 2 we cannot do it, because we are studying and preparing for Article 370. But this 437 consultants who have been fired by LG, right? So senior advocate Harish Salve, who was appearing for the LG, said these 433 consultants were rank illegal appointments. because they're telling all these 43 consultants were party workers. So, and he's telling, and Mr. Salvi is telling the court, okay, we accept, we agree that this decision should be referred by a 5-judge constitutional bench. So, what they're telling, the Chief Justice of India said, this is a cardinal issue. So, this cardinal issue will be decided by the constitution bench. They'll check whether this promulgation of ordinance amounted to an amendment of the constitution via ordinance route. So what they're telling, the ordinance that the central government passed, the Chief Justice will look into this issue. If the central government is resorting to ordinance to do constitutional amendment, so they'll look into all those things, because you know, right, constitutional amendment cannot be done through ordinance. So the Delhi government is also telling the same thing, that the ordinance took away its control over civil servants without amending Article 239 AA. So you all know what is Article 239 AA. So this is the constitutional article which talks about how the Delhi government should function. Only 239 AA gives legislative assembly to Delhi and all those things. So without constitutionally amending the article, they have made changes to Article 239 AA through ordinance route. So Delhi government is also telling this is unconstitutional. And next, what they are telling, control over civil services should be in elected government only. So they're telling this is only rational. And even the Chief Justice of India had orally observed that effective transfer of power over the civil services. So transfer of power of civil services means civil services is the Delhi government, but they are transferring the power of that to central itself. So he's telling this amounted to nullifying entry 41 of the state list of the constitution. So what is entry 41? Entry 41 is in 7th schedule. So what is 7th schedule? 7th schedule is only splitting, no, union list, state list, concurrent list. So entry 41 means state list. So the Chief Justice is telling, are you trying to nullify entry 41 of the state list? So what does the entry 41 of the state list talks about? It deals with the state's power over the state's public services and the State Public Service Commission. So what the Supreme Court is asking, see, you put an ordinance. So because of that ordinance, can the state legislature cannot enact a law under entry 41 at all? So entry 41 state only should legislate, right? But your ordinance makes them not to do it. So they're asking, so the states not do anything about it? And what earlier also there was a judgment given by the Constitution bench led by Chief Justice 𝐂𝐡𝐚𝐧𝐧𝐞𝐥. In that, what he did, that is in May 11, this judgment was given. In this, the Chief Justice had limited the power of the Lieutenant Governor. So who is Lieutenant Governor? He is generally considered an arm of the central government. And he is telling you have powers only in 3 areas: public order, police and land. With that only you have control. Other than that, you do not have control over bureaucrats. Like that the Chief Justice has told. So then what the central government did, within the 8 days after the court's verdict, they promulgated an ordinance. So in that ordinance, what they are telling, they took away the authority of the Delhi government to make laws and administer civil services. So this is what the Supreme Court judgment said, but in the central government, in their ordinance, they changed it again. So what the Ministry of Home Affairs is telling, what the central government is telling, so they filed a 33-page counter affidavit to the Delhi government's challenge. And what the Home Ministry is telling, the Parliament is competent and has overriding power to make laws even on subjects regarding which the Legislative Assembly of Delhi would be competent to enact law. So this is what the Ministry of Home Affairs is telling. All this will be looked by the Supreme Court. So what Ministry of Home Affairs is telling, even if the Delhi government can make laws on certain subjects, overpowering it, we can make laws. Like that the Home Ministry is telling. So so now that the case has gone to the Constitution bench, the court will look into all these things. So next they are doing all this political blame game, and the LG is telling, no, even we respect the judgment of Supreme Court, and the verdicts are sacrosanct for us. but they're telling don't take all these cases to social media because it is ruining the country's image and all those things. So that is not necessary for us. What we should see in this article is, can ordinance do amendments to constitution? You can't do it, but the central government has done it. So this case has now gone to the constitution bench. So the Supreme Court will look into it. Now let us move on to the next article. This article is about attack on Kerch Bridge. So in this article we'll see where is Kerch Bridge, why was it attacked, who attacked it, and things like that. So what is this Kerch Bridge? It is a bridge which links the Russian mainland to the Crimean Peninsula in the Black Sea. So see, this is the Russian mainland, and Crimea is here, and you see this bridge. This bridge was attacked. So there is no landmass connecting Russian mainland and Crimea. So there's a bridge which connects it, which was built by Russia, and this was attacked. So let's see what is this all about. So one section of the bridge was damaged. So Russians are telling this is an attack by 2 Ukrainian sea drones. But Ukraine has not taken direct responsibility for the attack. But its security services, SBU, said details of what happened to the bridge would be revealed after Ukraine has won the war. And in retaliation, obviously, Russia carried out massive airstrike where in a southern Ukrainian port city of Odessa. So Russia also announced. So after a few hours after the attack, it is withdrawing from a UN brokered deal. So what is this UN brokered deal? So this deal allowed Ukraine to export its grain via the Black Sea. So earlier Russia had enforced a naval blockade there. So Ukraine was not able to take its grains via Black Sea to other countries. So UN brokered a peaceful deal, which means the Russians were allowing Ukrainian food exports to go through that area. But now Russia is telling will no longer allow it. So this Black Sea Grain Initiative we saw yesterday, right? It is that only. So what happened to the Kerch Bridge? So what are Russian authorities telling? One section of the bridge was blown up, which killed 2 people and it injured a child. So a video footage was released by the local media, and in that if you see, the one portion of the bridge was tilting and hanging down. So what is this Kerch Bridge actually? The Kerch Bridge is across the Kerch Strait. It is 19 km long and it has 2 parallel rail and roadways. So on one side you'll have rail and on the other side you'll have roadways. It was opened in 2018 by Russian President Putin with a great fanfare because he is building that bridge after 4 years, because in 2014 Crimea was annexed from Ukraine. So after 6 hours after the attack, the rail service was restored, obviously, but the road remained shut. And this is not the first time that the bridge is being targeted, because last October, a massive truck bomb damaged the bridge and killed 3 people. So what is Ukrainian President Zelensky is telling? Is he termed the attack on the bridge as one of the successful operations of the Ukrainian forces. Why is this bridge very important? Because symbolically, administratively, and operational wise, it is very important for Russia. So when Russians annexed Crimea in 2014, there was no direct connectivity between Russian mainland and the Crimea. So we saw in the map, right? There's just waterways in between. So there was no direct land connectivity between Russia and Crimea. So what Russian president did? He immediately ordered the construction of the bridge. But the bridge remained a weak link because Ukrainians were militarily, they were getting very powerful because the West was actually helping them. And when Putin ordered a full-scale war on February 24, one of the main military objectives of Putin was to secure a land bridge from the mainland Russia to Crimea. So there are a lot of reasons for the war, but one of the reasons is he wanted this land bridge to Crimea. So that is also one reason. So Russia now, it has the land bridge extending from northeastern Ukraine through the Donbas and Kherson to Crimea. But it is not very far from the front line, and it is well within the range of Ukrainian fire. So it is risky only for the Russians. So 𝐂𝐡𝐚𝐧𝐧𝐞𝐥 bridge remains a critical logistic supply link for Russian troops in the south. Because it is in Ukraine, right? So there are few Russian troops there. So they have to establish logistic connections, right? So the bridge is very important. And again, the Ukrainians targeted the 𝐒𝐻 bridge because they were planning an offensive to retake Kherson. So why did they do it? Because the plan was to disrupt the supplies when Ukrainians attacked Russian troops on the western bank of the Dnieper River. So, but what the Russians did, they withdrew from the Kherson city in November to the eastern bank of the river. And last week's attack also came at a time when Ukrainians were doing counter-offensive. So the West and the Ukrainians are very clear. What was one of the key goals of the counter-offensive? The key goal of the counter-offensive was to destroy the land bridge. So what was Ukrainian strategy? The strategy was to make deep thrust into Russian-held territories of the southeast, reaching the Sea of Azov coast. So this would leave Crimea further vulnerable to future Ukrainian attacks, and this will leave 𝐒𝐻 bridge as the only link between mainland Russia and the peninsula. And obviously Ukraine also wants to disturb Russian supplies to the southern Ukraine, which is the focal area of their counter-offensive. So where does Ukraine's counter-offensive stand? So obviously, their counter-offensive started with advanced weapons supplied by the West. But Mr. Zelensky has consistently campaigned for more advanced weapons from the West to fight Russia. But the US and European allies, US and the US allies, they have supported armored vehicles, long-range rockets, cruise missiles, main battle tanks, and missile defense system. And they have given artillery shells and ammunition also. And they also give training to Ukrainian troops at different facilities in Europe and US. And the US alone has given close to 42 aid packages for Ukrainians. And in the latest package, what they have given cluster munitions. So this is a very dangerous weapon which is banned by over 100 countries because they cause a lot of harm to the civilians. So why the allies are doing it? Why the West and the US are doing it? Because they want to make swift battlefield gains against Russia. So what will this do? This will put a great pressure on Mr. Putin. That is why they are doing all this. But unfortunately, even after 6 weeks of fighting, Ukraine has not taken any breakthrough victory. So Kiev is telling troops have captured 210 square kilometers of territory since the counter-offensive began, mostly in the southeast. But they are all ghost villages. And anyways, Ukraine made only limited gains at a high cost. And what a New York Times report says, it is citing American and European officials. They are telling Ukraine has lost 20% of the weaponry it got from the West. So this 20% they lost in the first 2 weeks of the counteroffensive itself. And the battle lines also moved substantially only twice this year. So first was when Russians took Soledar, and then in May when Russians took Bakhmut. Why is it very difficult to take on the Russians? Because they have built huge fortifications along the 1,000-kilometer long front line, and before that they have mines and tank trams. So this has slowed down the Ukrainian counteroffensive. So this is putting a lot of pressure on Ukraine as well. So yesterday we saw this NATO summit in Vilnius, right? It is in Lithuania. So in this NATO summit, what happened? Ukraine got guarantees from its Western allies for more weapons and trainings, and Kiev also said the major thrust of counteroffensive is yet to begin. And yesterday is attacked the 𝐒𝐻 bridge. So this is what we've seen a full picture of what is happening in the battlefield. Now let us move on to the next article. This article is about India's data protection law. So the article starts by saying India is not Europe because recently, like 4 years back, European Union came up with something called as General Data Protection Regulation. So that's why the article starts by saying India is no Europe because in Europe they easily came up with this, but in India this will be quite difficult because we are going to have a data protection law for over 1.4 billion Indians. So what is this European Union's data protection law? That is the GDPR, General Data Protection Regulation. It came into force in the middle of 2018, and it achieved widespread popularity because it is the most comprehensive data privacy law in the world, because it includes things like right to be forgotten, so on and so forth. So it is the most famous data privacy law in the world. But GDPR also has its own challenges because there are issues with implementation, and there are risks being relegated to the status of paper tiger. So that is the problem with GDPR. So European Union's challenges are due to its unique legal structure, but India is on process of drafting its own data protection law. So India must safeguard itself against the risk of enacting a law that is toothless in effect. So what is the issue? So this monsoon session of Parliament, government is going to table India's first data protection law. So last year what they did, they released the Digital Personal Data Protection Bill for public consultation. So this is the third time they are trying to do this. So the draft release for public comments was not as comprehensive as its previous versions. So because last two times when they tried to table it in the Parliament, when it was sent for public consultation, it was very comprehensive, but now it is not. So what experts feel is there are critical gaps in the data protection bill which would affect its implementation and even its overall success. So what is the first main thing? So one thing that the author here wants to talk about is the data protection bill talks only about and protects only the personal data, and that is what is personal data. That is any data that has the potential to directly or indirectly identify an individual. But what experts are saying, so in the modern day economy, companies use various types of data, including both personal and non-personal data, to target, profile, predict, and monitor users. So what is non-personal data actually? It is a typical anonymous data that does not relate to a particular individual. So using this non-personal data, what they'll do, they'll aggregate data on product which numerous users look at 9 a.m. to 11 p.m. on Amazon. So like that they'll get data. So what they'll do, this non-personal data will be combined with the other data sets, and with this they'll help identify individuals. So, and this way it will become personal data, and this will impact our privacy. For example, the author is giving an example about anonymous data sets about individual Uber rider in New Delhi can be combined with prayer timings to identify members who belong to a certain community. So this can be done. So what they are telling, this is the process of re-identification of non-personal data, and this will pose a significant risk to privacy. So these risks were accounted in previous version of India's draft data protection bill in 2018 and 19, but they do not find a place in the latest draft. So what the author is telling, by not recognizing these risks, the data protection bill is very limited in its scope and effect, and in providing meaningful privacy to Indians. Because if you are having problems with just you're having problems with just personal data or non-personal data, and but if you're not looking at other types of data collection, then the whole law itself becomes pointless, right? So that is what the author is trying to tell here. So what the author is giving solution? A simple and effective solution, as in the earlier solution. So he's telling earlier itself you add it, no, you bring that. He's telling you add a penal provision in the bill, which will give financial penalties for data processing entities for re-identification of non-personal data into personal data. Next is talking about the limited reach of data protection board. So next what is telling, there's something called as the data protection board, and it is not given much power. So they are telling it will not able to initiate proceedings on its own accord. So what is telling under the bill, the board is the authorities that is interested with enforcing the law, and only the board can institute proceeding for adjudication if someone affected makes a complaint or the government or court directs it to do. So it's telling the board cannot take proceedings for adjudication on its own, but there's an exception to this. So that is when it wants to enforce certain duties listed by the bill for users. Other than that, it cannot take suo motu cognizance. So this is for the adjudication of disputes between law and the users. For example, let's take an obligation on the users not to register a false or frivolous complaint with the board, and not between users and data processing entities. So finally, what the author is telling, in data academy, users have diminished control and limited knowledge of data transfers and exchange. And you see this data economy, digital economy is ever evolving, and it's very complex. So users will always be a step behind companies. So for example, a food delivery app can sell all your data, and it can sell it to data brokers in violation of your contractual relationship with them. But individually, what can you do? Do you have the resources to fight them, or do you have the incentives to fight them? So you cannot do them. You can't do anything. So what is telling, the board, the data protection board, will be in a better position to proceed against the food delivery app on its own, on behalf of such affected users. But he's saying this is not a novel solution, because the Competition Commission of India is already doing it. So they are responsible for enforcement of India's antitrust law, and they have the power to initiate inquiries on their own. So he's telling you don't have to think a lot and all. There's a simple way to do this. Just have a provision in the data protection bill that will allow the data protection board to initiate complaints on its own. So you just give them this power. So he's telling these are not the only gaps in data protection bill, but finding solutions to them would help address challenges in implementation in a significant way, because if we keep addressing in the future, we'll get a more future-proof legislation. Now let us move on to the next article. This article is about the central government banning export of non-basmati white rice. So why they're doing this? Obviously to control price rise in India. So on Thursday they did this, and the Directorate General of Foreign Trade, which is under the Commerce Ministry, announced in a notification that the ban would come into effect immediately, and they are going to give exceptions to exports that have been signed before the notification was released. So let us know about more about this basmati rice. So this variety of rice constitutes 25% of the total rice export from the country. I mean the non-basmati rice. So what the Union Food Ministry is telling, so they're telling we have taken adequate steps to ensure availability of non-basmati white rice in the domestic market. So this will curb price rise. So how was non-basmati rice exported? It was exported under the category of free, but they'll have to pay export duty of 20%. So why they are doing this, because the domestic prices of rice are on an increasing trend, and the retail prices have increased by 11.5% over a year and 3% just in the last month. So that's why they're doing this. So export duty of 20% was put on non-basmati white rice because they wanted to lower the price, and the government wanted to ensure that there was enough rice available in the market. So in spite of this, export of this variety increased from 33 lakh to 42 lakh metric ton, even after imposition of 20% export duty. So why is this happening? Because in other countries, rice price has gone up because of geopolitical reasons, and El Nino sentiments have already come in, and there are extreme climatic conditions in other rice producing countries. So all these things have made rice price to go up, and people are buying Indian non-basmati rice. So the minister is telling right now we do not have any change in the export policy of non-basmati rice and basmati rice. But right now we are doing this just to ensure that the farmers get remunerative prices in the international market. So this is what this article is about. Now let us go to previous year questions. With reference to Mughal India, what is the difference between Jagirdar and Zamindar? So Jagirdar's judicial and police duties, no, the judicial and police duties were done by Zamindar. Jagirdars will do military operations. Land assignments to Jagirdars were hereditary, and revenue rights of Zamindars were not hereditary. No, Zamindar it was hereditary. For Jagirdar it was not hereditary. So the option is D, neither 1 nor 2. Land reforms, which one of the following statement is correct? The major aim of the land reform was to provide agricultural land to all the landless. Charter Act of 1813, it ended the trade monopoly of the East India Company in India, except for trading tea and trade with China. This is right. It asserted the sovereignty of the British crown over Indian territories held by the company. This is also right. The revenue of India were now controlled by the British of Parliament. This was already done in the Pitt's Indian Act 1784. So the answer is A, 1 and 2 only. Which of the following features Mahayana Buddhism? Which of the following are feature? This is a very simple question. Deification of the treading the path of Bodhisattva, image worship and rituals, all these are part of Mahayana Buddhism. So that's all for today. If you like this presentation, you can comment, subscribe and share it among your friends. You can follow us on YouTube, Instagram, Telegram and Facebook. Thanks for tuning in. I'll see you again tomorrow.